Record in 2 cases. Both of these are F1 murder cases. This is basically a rebond hearing in that Mr. Montgomery and Ms. Montgomery had a bond hearing, our initial appearance, on these new murder charges. They were previously charged with felonious assault F2. They were heard upstairs. Bond was set. They made bond. Then, while out on bond, the victim in the case, Mr. Benedict, passed away, succumbed to his injuries, and therefore the prosecuting attorney, Mr. Crawford, has now charged the Montgomerys with murder, F1. Bond was set on Friday at $1 million each, cash surety. Because they did not have counsel at that time, under Criminal Rule 46, the court is required to hold a second bond hearing within 2 court days. The court is going to do that at this time. Mr. Mayor, you're here in person, and Mr. Hitchman is president of the Crawford County Justice Center with his client, Mr. Montgomery. All right, Mr. Crawl, care to be heard on the issue of bond? Bond stands at $1 million, cash surety at this time.
Yes, Your Honor. The state would just reiterate what we said last week. Obviously, the change of circumstance is part of the reason why we asked for bond to be increased, is obviously they're facing more serious charges. I read several of your statements on the record. I won't repeat myself, but obviously they were indicative of horrible situation. Neither of the Montgomerys have prior criminal record, so the state's not going to fight for that fact.
I think Mr. Stover pointed out that Mr. Montgomery did have a criminal record.
Yes, he did. It just wasn't on his sheet here. Based on that, we believe that the bond was set appropriately, and we would ask that that bond be continued.
Okay. Mr. Mayor?
Thank you, Your Honor. James Mayer, 0072887, on behalf of Jaqueline Montgomery. Judge, my client is 43 years old. She's married. Co-defendant is her husband, one of the 2 co-defendants. Mother of 3 adult-age children, and she currently has custody of 2 other young relatives, ages 7 and 22 months. She's a longtime resident of Crawford County. She has a good job at Vitro in Crestline. She's been working there consistently for the last 6 or 7 years. They kept her on, kept that job available to her, and as far as I understand, she went back to work after she posted. She poses absolutely 0 flight risk in this case. I make that suggestion in cases I think it's appropriate, but we actually have something to go off in this case, in so much as following the posting of the bond on October 14th. It is my understanding that she has been strictly compliant with all bond conditions. She has refrained as ordered by Judge Leopold upstairs to refrain from any social media, any contact of any kind with the family of the victim in this case, and that's something she's taken very seriously. She's stayed home, been with the family, and gone to work. She's also maintained very close contact with me, coming to my office as frequently as I have time to meet with her to discuss her case, review discovery, and make sure that I know everything that I need to be aware of in order to best represent her. I mentioned October 14th, 2021, Judge. That is the date that we appeared in court for our arraignment on the felonious assault. At that time, her bond, as I mentioned, was set at $75,000 cash or surety. Of course, I recognize, as Mr. Crawl indicates, that there is a change in circumstance with respect to the more serious charges. That's clearly the case with the murder indictment. But I don't believe there's any change in circumstance with respect to what my client's alleged involvement is in this case, and also the fact that nothing has changed with respect to her bond the appropriateness of the bond that was set on October the 14th. Specifically, the state at that time indicated that of the 3 co-defendants, that she was viewed as perhaps the least responsible with respect to the assaultive conduct, which has caused her to be under indictment. And for that reason, the state at that time did not object and did not have issue with a tiered structure to the setting of the bond. most violent and most responsible with respect to the accusations in this case anyway. I believe his bond was set at $150,000. Tim Montgomery's bond, I believe, was set at $100,000, as I indicated, my client's bond was set at $75,000. So at least at that time, it was appropriate to kind of look at the accusations and the backgrounds of these individuals and determine if perhaps separate bonds should be set. And once that inquiry was complete, my bond ended up with half of the co-defendant Cameron Davis. With respect to bond factors, to reference criminal 46A judge, there were no weapons that were alleged in this case. As I indicated, I'm unaware, and the state has, I believe, confirmed this. I'm unaware of any prior record on my client at age 43. I think that says something about her. And we believe that there were some extenuating circumstances in this case that we were investigating. And as I understand the accusations from the witness in this case, my client is alleged to have thrown what amounts to one kick compared to the accusations against Mr. Davis, also Mr. Montgomery. So, Judge, ultimately, we can appreciate the state's position in requesting a higher bond, but given the fact that she posted what amounts to a very significant bond, she's not a woman of great financial means, posted the $75,000 bond, has done nothing to demonstrate that she can comply and make her court appearances. We think it's appropriate. She also has absolutely no drug issues, and we think that she can make her court appearances and abide by the conditions. Thank you.
Mr. Crow, any rebuttal?
Just I would note that alcohol was a major factor in this incident. Montgomerys were heard even before they were cut off by the bartender, having finished an 18 pack before they got to the bar. Before this happened, they had been cut off and were in the process of leaving the bar with the original altercation.
Okay. Of course, we consider all factors under Criminal Rule 46, and Mr. Mayor is at a bit of a disadvantage since he wasn't here at the last hearing, but the court will reiterate some of the highlight points of what it remembers from Friday's hearing. And that is Ms. Montgomery, her husband, and Cameron Davis were just joking. An incident started with Mr. Benedict, and the police were called. Mr. Benedict left the scene. It is at that point that the Montgomerys and Mr. Davis make what only can be viewed by this court as damning statements about what would happen if they took things into their own hands against Mr. Benedict and found him on Wiley Street. And then they ultimately sought him out and found him on Wiley Street. So, to my mind, these three individuals worked together to find Mr. Benedict. Once they found him, according to an eyewitness who described the entire events, I guess, on a 911 call, that one of the individuals, I think later identified as Mr. Montgomery, knocked Mr. Benedict down and unconscious. It was at that point that Mr. Davis climbed on top of him and started beating him, all while Mr. Benedict may have very well have been unconscious and completely unable to defend himself. Then got up to leave, came back, started beating him again. Then at some point, Mr. Montgomery came over and began kicking him in the head. Am I correct on that, Mr. Crawford?
That's correct, Your Honor.
So this is a gentleman who, whatever problem they had with him, had left the scene. And is at that point, law enforcement was involved. If law enforcement took a statement and they believed that Mr. Benedict had done something criminal in nature, it was law enforcement's duty to investigate it. Mr. Montgomery says, I'm taking this into my own hands, and I'm going to go find him on Wiley Street. And he did. And he did. And then after he knocks him out, him and Mr. Davis continued to beat and stomp Mr. Benedict while he was unconscious and unable to defend himself. And then, after both men had finished beating this man, your client, Mr. Mayor, walks over and kicks in the head a defenseless, unconscious individual. The court, when looking at criminal 46, ID is very strong. Not only then were they identified as the people who beat this man, they later were interviewed and basically confessed that they beat him up. I believe, correct me if I'm wrong, Mr. Kroll, what statement did Ms. Montgomery say after when they interviewed her?
Yes, when she was interviewed by the
Could you
officer.
please speak up, too?
Yes, I'm sorry, Your Honor. Ms. Montgomery stated, and I'm quoting from the police report, she doesn't remember it too much. It was dark outside, but she knows Cameron had hit him or kicked him or something. Mrs. Montgomery stated he fucking deserved it. Apologize for the language.
So, court looks at criminal 46 and says, in Ms. Montgomery's mind, he deserved what he got.
I have another statement.
Go ahead.
She then added, that is not my fault. I don't feel bad for him. I guess he won't beat on women more.
Okay. Was there any evidence that Mr. Benedict had assaulted her in the bar?
She has visible injuries, Judge, that I photographed.
I'm not talking to Mr. Mayor, I'm talking to Mr. Kroll. I will give you a chance. I will give you a chance to respond. Is there any evidence of that?
Your Honor, the officers observed a mark on Mrs. Montgomery after the entire assault occurred.
Not before.
They had been in the bar and were in the process of, and additionally to that, they did not observe any visual injuries at that time. They were also looking at any camera footage from the bar to see if there would be any visual injury there as well. I haven't heard that they accomplished that.
Okay. Mr. Mayor?
Yeah, Judge, she does claim to the police that she was struck, pushed, and she, at least my observations.
Where was she struck?
Injuries, wrist area, collarbone area, as I recall.
So, in her mind, getting struck in the wrist and the collarbone justifies stomping a man's head until he dies. Is that the...
So I'm not here to try the case, Judge.
No, I understand that.
But
I'm here to argue bond on
fine.
criminal 46 on I'm looking at the weight of the evidence.
And I get it, but I don't think, as we're looking back at those statements that my client provided, that there's any point in time where she acknowledges that she did any striking or kicking. And so we understand that there's an eyewitness. We also understand he's in an upstairs window. There's distance and it's nighttime. So she absolutely takes issue with the accusation that she kicked.
Okay.
And no matter what, it's one strike that she landed, and yes, that witness indicates that it is the last strike. I get it. But comparatively, if you read that report, she is clearly the least involved in the three. And that's the point that I'm making with respect to why I think if bond is to be considered on a tiered structure, which it was earlier in this proceeding, that she would be reasonably set at the lowest of the three. Because by that eyewitness's account, she is the least involved physically.
I would agree with you that
And that's the point.
by the eyewitness's account, she delivered the least amount of blows. The question then, and the question that will eventually come later on, is proximate cause of death, which I think is pretty obvious from blunt force trauma, which led to that. But I think that, and Mr. Kroll, depending upon how you intend on ultimately charging this, if you look at, and I'm looking at the statute, for murder, it says no person shall cause the death of another as a proximate result of the offender's committing or attempting to commit an offense of violence that is a felony of the first or second degree and that is not in violation of 2903.03. So I think when looking at this fact pattern is, the question is, when a man has been beaten down, unconscious, and unable to defend himself, does kicking him in the head rise to the level of a second-degree felony, which one could argue would be felonious assault? Don't know. And we're not there at that stage yet. So, but if it was, your client is looking at a life sentence with the possibility of parole after 15 years. This court, in looking at all factors under Criminal Rule 46, is allowed to put weight on I'm allowed to put weight on certain factors more than other factors. And I will concede with you, Mr. Mayor, that your client is 43 years of age, doesn't have a prior criminal record, is a long-standing member of the community. However, the court is not required to weigh these factors evenly. And the horrific fact pattern, and then the attitude of the co-defendants as well as your client after the fact, shocks the conscience of this community. And so therefore, at this time, I'm going to keep bond at $1 million cash. I think that Ms. Montgomery, with her actions, if true, does present a danger to people in this community. And this court has a duty to protect its citizenry from people like Ms. Montgomery if this is the kind of behavior that she's going to engage in, and then truly show no remorse for the victim. Bond stays at $1 million.
Thank you, Judge.
Mr. Montgomery.